Hello, everyone. I have the pleasure of introducing Madam Alla. She's going to talk about AI, IP, and your code, especially what developers need to know.
Thank you. Hello, thank you, and welcome to my session. I'm really excited to talk about AI IP and your code, what developers need to know. I'm hoping that folks can walk away from today's session feeling more informed and mindful about copyright and licensing issues involving AI generated code. So, with that, I'll provide a brief intro to myself. I am a former lawyer licensed to practice in California, but I'm currently on inactive status. I also did not practice in the copyright arena, but I've since transitioned into another field. Currently, I am a freelancer in the trade show and experiential marketing space. And I'm also a self taught software engineer focusing on Python. And I'm also an inspiring developer advocate. So, excited to talk to you about these issues. But before we jump in, I need to provide a brief disclaimer that nothing in this presentation constitutes legal advice of any kind, nor does it form an attorney-client relationship. This is all for informational purposes only. If you need legal advice, please consult your own independent counsel. In the same vein, I'll also mention that this presentation is highly US-centric, so unfortunately I won't be digging into international concerns too much, but I'll try to bring them up when possible. So now that we have that out of the way, let's jump in. Here's a quick agenda to orient you to what we'll be discussing today. Quick overview of IP law. Then we'll discuss copyright implications of AI generated code, followed by some tools and solutions that you can implement for handling AI generated code in your own workflows. And then if there's any time remaining, we will do a Q&A. So let's start by thinking about IP rights in terms of why they were created. So before we even talk about when they apply, we'll just talk about how they apply to creative endeavors and why do we attach these intellectual property rights to creative endeavors. In the US, this is actually constitutionally mandated to give an incentive to creators to make creative works. And creators here is a broad term. It includes authors, and inventors and other engineers and scientists. So it's a broad term. And these creators are given this special exclusivity right to their works. And the idea is that because they have those special rights, they will be able to have a financial incentive to continue creating creative endeavors, and then those rights actually terminate after a while. So they are only for a fixed duration. It's different in other jurisdictions because of a concept called moral rights that we don't have time to dig into today. But upon expiration, those creations then go into the public domain for everyone's benefit, so the rights expire. And so now that we know why we have intellectual property rights, let's talk about some of the areas they cover. So there's three primary areas. There's copyright, trademark, and patent. And so copyright would work for creations such as literary works and other artistic expressions, including audio visual expressions. And so it's pretty broad, but you can think of artistic expression broadly, including literary works, movies, movie scripts, paintings, photographs, so a very broad range of artistic expression. And we will circle back to copyright because that is what the bulk of this presentation will focus on. There's also trademarks. So trademarks would relate to branding as well as logos. So kind of another area related to trademarks is trade secrets. So those protect business secrets like customer lists. So then there's also patents. Patents protect inventions, and that could be related to an issue that could come up if you're using AI generated code, because you might think of, well, what if I create AI generated code that will allow me to implement an algorithm in a novel way? So although algorithms themselves do not receive patent protection, you can receive patent protection for implementing an algorithm in a novel way. And I won't get into the specifics of that, but you could hypothetically use AI generated code to implement an algorithm in a novel way. So that means that you're not simply executing the algorithm in code, because like I mentioned, algorithms themselves are just abstract ideas that do not achieve patent protection. So just some food for thought there. We're not going to delve too much into that area, but I'll provide one more note before we switch back to talking about copyright and licensing. So with patents, this idea of simply an abstract idea for algorithms has actually come up in recent court cases, and there was an important case, Alice Corp versus CLS Bank, in which a number of patents were determined to be faulty because they were simply executions of algorithms. So just code that was executing an algorithm and nothing more. And so the court determined that that does not achieve protection under patent law. So that is really important and potentially could invalidate a number of other patents that are already registered. And one final note on patents, you do need to register them to receive protection. And so that is in contrast to copyrights, which we're going to switch back to for the rest of the presentation. So I already mentioned that copyright covers this wide range of artistic expression, including literary works. And that is where software code falls in. Software code is considered a literary work for the purpose of copyright. And with that in mind, what rights do we have for copyright? So it's the right to copy, reproduce, distribute, and the creation of derivative works. And so the creation of derivative works is quite an interesting element of that exclusive right. So not only do you get to ensure that you don't get copying or distribution, no one can create a derivative work on something that you've copyrighted. So it's very important to consider and will be really important when we talk about software licensing more later in this presentation. So some other notes about copyright. So we did talk about how they cover artistic expression. And so that means that it really has to be a creative artistic expression. They do not cover ideas or generic instructions. And so if you're at all familiar with the Google versus Oracle case about APIs, there was a big question there in terms of this dichotomy between ideas and expression. Expression is covered, ideas are not. And so in the same vein, if you're thinking about software code, something like for X in my list, print X, that's very generic. It's just an idea that you've expressed in code that wouldn't be copyrightable. So when you're thinking about these issues in terms of AI generated code, it's important to remember that some of what you might be using might just be a general idea that is not going to receive copyright protection. So now that we have a brief overview of IP, let's dig into the idea of software code licensing, because within the software arena, when we think about copyrights, we're often thinking about them more in terms of licenses than copyright specifically. So there is a big bubble here that says proprietary. That is where we see a reliance on those traditional copyrights that we already discussed. So no third-party reproduction or distribution or creation of derivative works on that proprietary code. That's typically something that is protected by companies, so proprietary meaning used by businesses. There's also a small bubble here, public domain. It's pretty rare in the software arena to see public domain code. And like I said, this isn't drawn to scale. So the idea behind public domain is those are those creations that are out available to use for anyone. So some examples of something that are currently in the public domain that are not software code are things, well, actually, one is somewhat related, but not under copyright. So you can think of like Google's PageRank was patented, now it's in, the patent has expired. Similarly, like Winnie the Pooh's patent has expired. So those are things in the public domain. Sometimes people also try to add to the public domain using something called an unlicense, and there's implications regarding that in terms of international contexts where there's moral rights. So something to consider if you're thinking about these issues on an international level. And then there are the two areas that I think we tend to think about a lot as software developers: permissive open source licensing and copyleft licensing. So these are all kind of under the open source umbrella. And when we think about open source licenses, we need to remember that they still rely on copyright. You don't have any rights under your licenses unless you have that initial ability to copyright. So if there were no copyrights available to you, you wouldn't be able to attach open source licenses to your code. So with that in mind, we can start by talking a little bit about permissive open source licenses. So those are licenses like the MIT license or the Apache 2.0 license that you're already familiar with. And so those licenses allow you to give up some of your rights as a copyright holder and say others can freely use, distribute, and create derivative works with this permissively licensed code. And though you're giving up a lot of rights that you have under copyright, you do retain certain restrictions, or they're not restrictions in the same way as we'll talk about copyleft, so I want to clarify that. But you do continue to use this idea of attribution with your permissive open source code. So you do say that there needs to be an attribution to the original author, as well as the license has to live alongside the life of the code, even in downstream versions. So that is really those important considerations of open source that is permissively licensed. And then we can talk a bit about copyleft licensed code. And so that does provide a restriction that goes beyond what copyright allows for. And so there's two types, there's weak and strong, and I think a lot of folks are probably familiar with strong copyleft in the form of the GNU General Public License. And so under the GNU General Public License, also known as the GPL, there is a requirement that goes beyond copyright that adds this new restriction. And so that restriction is that if you're going to use or create derivative works of this copylefted code, you need to ensure that you use an equally restrictive license or a more restrictive license. So that's really important because the goal there is to ensure that that copylefted code doesn't end up in this big proprietary bubble, even though we see in this model that it does overlap. And the reason is that companies will still use copyleft code and include it in proprietary code, causing licensing conflicts. And so in terms of a licensing conflict case that is currently being litigated, there is the Software Freedom Conservancy versus Vizio Smart TVs. And basically, Software Freedom Conservancy is arguing that Vizio needs to release source code for their SmartCast technology that, among other pieces of copylefted code, includes the Linux kernel, which is licensed under the GPL. And under the GPL, this couldn't have been put into a proprietary source code. So Software Freedom Conservancy is obviously not the original author of the Linux kernel. So in terms of this argument, they're arguing that because there's this new element outside of copyright, there's a breach of contract, and under that breach of contract, they breached the license by adding this source code to the proprietary code base that users can no longer use to get to that GPL licensed code. And so what's interesting here is that though they're not the author, the court has actually ruled that they do have standing to bring this case. And so basically they have standing under what's called the intended beneficiary doctrine. So even though they are not a party to the contract, you know, they're not the original author of the license, nor the one that is using the code that's licensed, they are able to bring this case because they are an intended beneficiary under the GPL. So that is something that has already been ruled on. The case has not been fully litigated, so it'll be interesting to see how the entire case plays out, because that could mean that copyleft compliance will be a much bigger issue, and that companies may be forced to look into their proprietary code bases and ensure that they are not building proprietary code on strongly copylefted source code. So that is some of the background on software code licensing that will hopefully inform the rest of this conversation on AI generated code. And as we can see, these are very timely issues that are getting a lot of scrutiny in courts right now. So moving on into the realm of AI generated code, there is a question of AI authorship. So we'll start there with this idea of AI authorship. Who can copyright AI generated code, if anyone? So let's say that somehow I'm able to write this genius prompt that allows a generative AI system to produce an entire program from just one prompt that looks at all of my analytics from my smartwatch and then creates these customized fitness plans. They write all the code for that program, and then I'm like, well, this is an amazing program that I'm using. I should try to capitalize on that. Well, there are going to be a number of issues. So because the entire program was created through AI, the author is AI, and AI cannot be a copyright holder. And that actually arises because of a series of interesting disputes known as the monkey selfies disputes. And so there was a well-known British nature photographist, David Slater, who went to Indonesia to capture photos of these really beautiful and interesting macaw monkeys. And he set up his camera on a tripod with a remote trigger, and the monkeys took photos of themselves. And they were really interesting, wonderful photos, like the one you can see on the PowerPoint. So then David Slater tried to enforce his copyright to these photos, but he didn't take the photos. So when he asked Wikipedia to remove one of the monkey selfies from Wikipedia, he was unable to do so. And Wikipedia said, "You're actually not the author of these photos. The monkeys are." So in a subsequent case, there was an action brought by PETA on behalf of the monkeys, Naruto versus David Slater, in which PETA argued the monkeys need to be compensated. They are the authors of these monkey selfies. And they did not prevail. So the court decided that under the Copyright Act that monkeys are not human authors, and only human authors are eligible for copyright ownership. So a very interesting case that informs how we can think about AI. AI also is not a human author and therefore cannot hold copyright. So anything creative developed by an AI is not copyrightable. And then in that same vein, there was a recent case that regarded registration of a graphic novel by a content creator named Chris Kushtanova, who made a graphic novel called Zarya of the Dawn that, interestingly enough, uses images of the well-known actress Zendaya, and not direct images, but I'll explain how these images were created. So Kushtanova inputted prompts into the well-known image generation service known as Midjourney. So then these panels were created, and they were all created through Midjourney, and then Kushtanova added text and then assembled them into a graphic novel. And at first, the Copyright Office was unaware of the AI aspect of this novel, so they approved the copyright registration, and then subsequently they came back and said, actually, you can't copyright this entire work because there are portions of it that are not copyrightable. So the unclaimable content was those individual panels that were created by Midjourney. However, the comic as a whole, the text and the assembly of the comic strips was copyrightable. So the case there just shows how the Copyright Office is looking at AI generated code. There are some other, I mean, not AI generated code, sorry, AI generated content. And so there are some other cases in the same vein in terms of how the Copyright Office is thinking about registration of AI authored works. And so just again to reiterate that the AI authored portions of something are not copyrightable, but that doesn't mean that something that's, for instance, a derivative work of something that's AI generated or that does have some human authorship component could be copyrightable. So that's very important to note. And so now that we have a sense of how AI authorship is treated, let's talk about how this AI authorship can even happen. So these AI service providers are using large language models that are trained on massive sets of training data. And there's a question of where does this training data come from? And typically it's all black box. And so that means that it's black box even if you're using an open source LLM, the training data is typically still always black box. So we don't know exactly what is contained in it. And what that means is there could be content that's contained that's copyrighted, maybe something was pirated and put on, and by copyrighted here I mean traditionally copyrighted. Pirated content could have come from a website that unauthorized was still putting on this content. And then in the same vein, there could be code that's licensed either under a permissively open source license or a strong copyleft license, right? So there's all of this training data and we really don't know what it's comprised of. So with that in mind, there's a question even from just the idea of what's happening during training where there could be an issue of direct infringement because these companies are taking these giant sets, and even if they have a book that they had a legal copy of, they might still make an unauthorized copy and then use that either in their training data set or in a training process. So with that in mind, there's a question just on the initial front end of, is there copyright infringement when models are trained? And that is currently being litigated in the Thomson Reuters case, so it'll be interesting to see how that pans out. And then obviously there's a question also on the other side of things, the output side of things. Is output that is being generated a copyright infringement? And so there are also a number of interesting questions. As we talked about earlier, copyright does protect derivative works, but courts have held that just because a training model has seen your book doesn't mean that every single output is a derivative work of your book. That has already been decided. But on the other hand, there's something called regurgitation that could be just a direct output of something that came from the training data itself. So as you can see, here is an example from my own ChatGPT account of I prompted make a comic of a dog saying this is fine. The output is the well-known Casey Green gun show comic panel of a dog saying this is fine engulfed in flames that became a wildly popular meme. So in this case, it does seem like the system has outputted something that is already copyrighted. And in that vein, I will note that the larger these data sets are, the less likely something like this is going to happen. So there is definitely a balancing of interests of the more data you have, the less likely this will happen. But the more data you have, it's also more likely that you might be directly copying something or otherwise not taking into account creators' interests on the front end. So interesting, a balancing of interests there. And so thinking about that balancing of interest comes into this question of fair use, which a lot of folks here might have heard about the fair use doctrine and two popular cases. And so these are the four prongs of the fair use case, but we're really only going to talk about two aspects of the fair use doctrine: transformation and economic impact. And so in terms of the transformative nature, two cases did find that there was both transformation and a minimal economic impact. The first is the Google Books case, where Google digitized millions of books and then allowed users to search through those books and get little snippets back that were around the search term, and courts determined that was a transformative use because it allowed users to do these really interesting search queries, as well as it actually could have had a positive economic impact, if no economic impact, because users might now be familiar with the book or find out that a book has a search term they're interested in, so they might buy that book. In another interesting transformative fair use case, there was the Google versus Oracle case, in which Google used 37 Java APIs that were protected under a license originally owned by Sun, that the courts ruled when Google used them to create the Android operating system were transformative fair use because Google was allowed to implement a familiar language in a different environment, and the economic impact to Oracle was minimal. So that was actually decided by the Supreme Court. And if you look at the history of that case, you might be sitting at the edge of your seat because it just keeps going back and forth on copyright issues, and definitely delves pretty deeply into this idea of the dichotomy between idea and expression. So very interesting to look into if you're interested in these matters. Oh, and actually, before I move on, we'll make one more note about fair use. So this idea of the LLMs, I actually didn't really discuss. So how do we think about LLMs in terms of the transformation and economic impact? I think a lot of folks would say that yes, this is a transformative use of the data that has been used to train these models, but the economic impact issue is a little bit more tenuous. And in fact, there's a lot of creators that are arguing that the use of these training model processes has eliminated the market for their work entirely. So that could potentially, according to some lawyers, lead to an extinction level event for AI. We will see how that plays out. There's a number of cases. I think there's at least 25 cases right now that are tackling these issues. So that is the argument that LLMs might be using. And so now in the last few minutes, I want to talk about, given this very comprehensive background, how can we make sure that we're using AI generated code in a careful and responsible way so that we can ensure not only that we're not violating copyright, but that we're also being very attuned to the licensing requirements imposed by our fellow developers, whether that be in the open source community or otherwise. So I would say first and foremost, if you're using AI generated code, carefully use it, use code that you understand. That really applies to any borrowed code that you're using. If you're finding code on Stack Overflow or elsewhere, you want to be careful about understanding it, not just for licensing related issues, but also because you want to be able to debug, maintain, and ensure that your code doesn't have security vulnerabilities. So by using code you understand, that is very helpful. And then I will say that a lot of these are actually best practices even outside of AI generated code. They'll apply to you regardless. So if you're already doing these things, then you're already a step ahead. If you're not doing these things, then the AI generated code is adding an extra layer of liability, potentially. So in the same vein, if you use smaller snippets of code when you're using AI generation tools, that means it's more likely that you might just be copying an idea, and you're less likely to copy something that's either licensed or copyrighted. So in the same vein, you might want to consider licensing issues during code reviews. Consider if your colleagues are using these tools, and if you notice that there's any potential use of open source licensing that's not being attributed properly. And then in the same vein, follow your employer guidelines. Your employer might have already developed a policy related to AI governance issues. So those are all about careful usage. It's also really important to have solid documentation when you're using borrowed code, not just AI generated code. And so if you are using code, you want to know where it comes from, especially if it's under a copyleft license, because that could have a lot of future implications down the road. And in terms of documentation, you also want to identify AI generated code and AI authorship. So in terms of identifying AI authorship, there's a question about registration, as we discussed earlier. You will not be able to claim in your copyright registration anything that's AI authored, though you just have to note that there is AI authorship. You don't need an entire spreadsheet of every single line of code that was developed that is AI generated. So on the other hand, if you're worried about licensing issues, you might want to have that spreadsheet to make sure that you know all of the code that's been generated by AI and how it could potentially be from an open source licensed repository. And then in the same vein, automated code audits are super helpful here. You can use tools to do source composition analysis that will both look at all of your source code and compare it to open source repositories to see if there's any matches, as well as it can also look at your source code to look at all of your imported licenses to make sure that that downstream flow of licenses is all in compliance. So those are some tools that once you find the right ones, you can implement them into your continuous integration, continuous deployment process. So that way that tool's running automatically every time you push. And then as a final note, I'll talk about indemnification in terms of services, hopefully very quickly. There are indemnification clauses that certain AI providers give you when you're using their tools. Oftentimes they're very limited. They typically apply to enterprise customers. And so there's also a number of other restrictions that might follow from trying to rely on them, including maybe if you aren't using the right safety guardrails or you're adding another layer of software on top of the generation, that might invalidate the indemnification. So if your plan is to rely on those, maybe consult with an attorney. Similarly, I think for the GitHub Copilot one specifically, you have to block public code suggestions in order to take advantage of the indemnification clause. But just generally, you might want to block public code suggestions to ensure that you aren't mistakenly incorporating open source licensed code that is either not attributed properly or not considered in terms of copyleft. And then finally, I'll talk about prompting carefully. So there is a question in terms of your specific terms of service with these providers, if you're not an enterprise user especially, where you don't know where your prompts are going, so you might inadvertently reveal a trade secret or other information that's sensitive. So be really careful to make sure that you're prompting carefully, especially depending on your specific situation if you don't have an agreement with these providers. And all right, with that, I think I have gone through all of these notes, but like I said, I think here it's really about following these best practices even outside of AI generated code. So definitely a lot of interesting issues here. So I think we'll all be on the edge of our seats as the litigation plays out. And I don't know if maybe we have some time for a Q&A, but if you want to keep in touch, here's my email. I'd love to get any positive or negative feedback. I also am happy to provide suggested reading or informational resources if you want to learn more about these topics, and I would love to connect with anyone here as well. So thank you so much for joining me. Okay, perfect. Yes, sorry.
So I'm gonna use this mic. So in your presentation, thank you, because it was really good introduction to the concepts of IP and IP law. I'm the executive director of the Open Source Initiative, and when you presented the data set, the conversations or the topic of the data, the assembling of the data sets to train AI. You gave me the impression that you were giving absolutes, like the books being scanned, books 3 specifically, and the fact that that data was assembled to train LLMs was copyright infringement. And later in your presentation, you mentioned the books, Google Books case. So what's your position in there? Like, can you clarify what your thinking is? Like, it was fair use for Google, but not for
no, that's an open question. So the whole point is it's an open question. So I'm saying there could be direct infringement, but we don't know because this fair use question hasn't been litigated in terms of these specific LLMs yet. So that's why I'm saying we're all on the edge of our seats to see how this plays out. At least I am. I hope that answered the question. I think there's one more.
Are there situations where a permissive license like the MIT license can be rescinded, and does that matter? And also, what are the criteria for distinguishing between AI-generated content and new content that's inspired by AI-generated that is copyrightable? Great talk, by the way.
Oh, thank you. So in terms of the first question, I think there's definitely a lot of nuance that I wasn't able to cover just because this talk's only 30 minutes. So, I mean, even just beyond something that's MIT licensed, there's a lot of times where things are dual licensed, or there could be like other provisions that are attached to a license. One thing I wanted to mention, though I didn't have time, are these like derivative licenses that you have to be really mindful of. So it looks like the MIT license, but they added like a new term. So definitely be cautious if you see anything like that. But yes, there are instances where, you know, there's this MIT license applied, but then there's these other restrictions maybe coming from a dual licensing situation. So you do want to be careful. But then also, if it is MIT licensed, because any derivative works are freely open to use, they could still end up in proprietary code, right? So a future version could be licensed under more restrictive license, whether that be copyright or copyleft. So the flow really goes in any direction with something like the MIT license. I hope that answered that question. And then in terms of the next question, I think, and I did want to mention this, but again, time constraints. If you're just using something like ChatGPT to brainstorm or Claude to brainstorm, then that brainstorming is likely just a part of the creative process that would not rise to the level of AI authorship. I mean, obviously that could be a fact-dependent inquiry, but generally when you're just using tools in certain ways, they might not rise to the level of AI authorship. So if you're just spitballing ideas and then you write your own function, that's totally fine. Does that make sense or answer the question? Perfect.
Thank you for the exciting talk. Do you have any particular recommendations for tools to do the automatic source code auditing that you suggested?
I was doing a pretty deep dive into this, and I am still not comfortable recommending anything yet. I'm planning to do more research, so if you want to like keep in touch, I'd love to potentially offer some more guidance on that in the future.
Thank you so much.
Extinction level events. Do you mean like throwing training models away?
I mean, that is what some lawyers think could happen. Honestly, I will say I don't think that will happen for a number of reasons that are more opinion-based, that are probably outside the scope of this topic. But there are attorneys that feel like this market issue is so determinative that it could result in massive findings of copyright infringement, because there wasn't really consent in building out these data sets. And so now there's kind of a push towards training new models on data that is more consent oriented. So there's a lot of ways to think about the next generation of models. And in fact, I had a slide in this presentation that I removed because there just wasn't enough time to address it, but it was your code as training data. And I did a bunch of deep dives on like some issues there as well. So just there's too many issues to discuss in such a short time frame. Thank you, everyone. Thank you so much.